Hello, welcome, and thanks for joining this webinar. With increasing digitalization, cybersecurity is becoming more and more important. Digitalization makes our everyday business and private lives easier, much easier, but at the same time, however, new protection gaps are emerging that needs to be filled. The daily attacks from cyberspace are constantly increasing. The legislators have recognized this growing threat and passed a number of laws in the recent years to counter it. Cybersecurity is essential for our governments and is also an economic asset. Only IT systems that can withstand attacks from cyberspace are what enabled us to protect our trade secrets, government secrets, or personal data or other information. So my colleague, Azaf from Gornitsky & Co. and I thought that this is reason enough to talk about and to look at how the Israeli and the European legislator is dealing with cybersecurity. So we are thrilled to share our experiences. And well, before we start, just short information. We will provide our slides after the webinar, and you're free to use the chat to ask us questions, and maybe we have the time to answer them here in that webinar or maybe afterwards. And now I'm looking forward to the presentation of my colleague Azaf. It's your stage.
Thank you very much, and thanks everyone for joining this webinar. My name is Asaf Arel. I'm a partner at Gornitsky & Co. based in Tel Aviv, and I had the cybersecurity and data protection practice at the firm. And in the next 10 minutes, I will provide a quick overview about cyber regulation in Israel. Now, as Maraika said, our focus would be on cybersecurity requirements that apply to companies. Please note that Israeli law also regulates the development of certain cyber technologies, and that we will not discuss such requirements on today's webinar. So before we address the legal framework, let's talk about recent events. And I think this will provide some context on the legal requirements. 2020 was an unprecedented year in terms of cyber attacks on Israeli companies. And the reasons for this include, among others, COVID-19 and the work from home, but also the geopolitical context. Basically, experts believe that many of the attacks on Israeli companies originate from Iran. And I would like to show a few examples of some of those attacks. So first one in April, there was an unprecedented attack on Israel's water supply system, on a company that actually provides the water services to the people of Israel. And according to media reports, the cyber attacks was launched in an attempt to increase the level of chlorine in drinking water in Israel in a manner that could have endangered the health of Israelis and also could have disrupted the water supply. In addition to that, in December, another cyber attack was launched against an insurance company named Sherbet. Now, this attack was a ransomware attack, and the hackers threatened to publish documents of the company containing personal data if their demands were not met. They demanded approximately 200 bitcoins, which is basically 6 million euros. Now, when the company did not pay, the hackers simply published certain documents on Twitter. They published IDs, driver's licenses, etc. And as an insurance company, Sherbet's activities are regulated by the Israeli Ministry of Treasury and subject to its cybersecurity guidelines. And accordingly, several government agencies were involved in the handling of this event. These included the Cyber Directorate, the Ministry of Treasury, the Data Protection Authority, because we had personal data involved here, and the Israeli police. Now, there is a growing trend in Israel to file class actions pursuant to data breaches that exposed personal data. And accordingly, a request for a class action was also filed against Shearbit days after the publication of this matter. In addition to that, in the past year, we've seen attacks on technology and defense companies, and these also affected the general atmosphere in that regard. So moving to the existing legal and regulatory framework. The laws actually that are meant to protect from such events. The type of cyber regulation that applies to a certain company is generally determined in Israel by the sector in which that company is operating and the type of data that is processed by the company. So, for example, operators of critical infrastructure, as well as the defense industry, are subject to cyber guidelines issued by the Israel Security Agency and the Cyber Directorate, the NCD, under the Security in Public Bodies Law. In addition, certain regulated entities, such as financial institutions, healthcare providers, etc., are subject to regulatory guidelines on cyber issued by the relevant sectorial regulator, who also monitors compliance. So these requirements generally include corporate governance requirements, internal accountability regarding cyber, also certain requirements to conduct risk surveys, penetration tests, to report cyber events to the regulator, to manage the supply chain risk in terms of cybersecurity, and so on. And in addition to that, any company that holds personal data in Israel is subject to cybersecurity requirements under the privacy protection regulations. Lastly, there is also a proposed cyber law, which we will discuss in the next slide. So as mentioned, any company that processes personal data in Israel is subject to the privacy protection regulations. These regulations that entered into force in May 2018 impose certain cybersecurity requirements. Now, compared to GDPR, to the European General Data Protection Regulation, these regulations are much more specific on cybersecurity. And the key requirements under these regulations include, for example, the need to adopt an information security program, to manage access permits, conduct risk assessments, employee training, manage the supply chain in certain instances, report personal data breaches, conduct penetration tests, etc. The scope of security requirements that apply to a certain company is mainly determined by the type of data, the number of data subjects, and the number of persons with access to data processed by that company. And that brings us to the proposed cyber law. This is actually a memorandum of law that was introduced in June 2018, but still has not been enacted. Now, since the publication of the memorandum, there has been a lively debate on it and on the powers that it is supposed to grant to the National Cyber Directorate. So to give some context, I have to say that this memorandum of law is driven by a national security approach. And the fundamental concept here is that due to the connectivity of computer systems, national cyber resilience requires government involvement in protecting the private sector. So in that case, an attack on one company can quickly affect other companies, also affect critical infrastructure and the government itself, and turn into a strategic threat on the state. Therefore, the memorandum proposes granting the National Cyber Directorate broad powers for detecting, preventing, and handling cyber attacks in the private sector. These powers include, for example, entry into non-residential places, demand documents, seizure of computers, to give instructions to organizations on cyber, etc. The default for this should always be consent, but the Cyber Directorate can also act without consent, generally depending on the level of risk. So in case of a high risk of a cyber attack, the Directorate would usually be able to act without consent. Now, pursuant to a lively debate on those broad powers, the Ministry of Justice mentioned that powers will be more limited when the bill is introduced to Parliament. But it is yet to be seen what exactly such limitations will include. I also want to mention that the proposed cyber law will also impose certain corporate governance requirements on certain types of organizations, mainly to conduct periodic board meetings on cybersecurity as a way to softly promote cyber defense. And in addition, it will also regulate the interplay between sectorial regulators, such as the Ministry of Treasury, the Ministry of Health, etc., and the National Cyber Directorate. So, as a bottom line, to minimize risks for legal exposure with respect to cyber in Israel, companies should generally first understand which laws and regulatory guidelines apply to them based on the sector in which they are operating, and also based on the question whether they are processors of personal data. In addition to that, it is also a good idea to implement industry standards such as ISO 27001, SOC 1, SOC 2, etc. And in addition, the National Cyber Directorate also issues non-binding recommendations that can promote cybersecurity in companies. And of course, beyond these requirements, there are also the common recommendations for handling cyber threats in organizations, accountability, cyber insurance, and so on. So it is also interesting to see whether the cyber law will be introduced in 2021, perhaps after the new government is sworn in after the elections. So thank you very much for listening and for joining this webinar. Malaika, now the floor is yours to discuss cybersecurity in Germany and the EU.
Thank you very much, and thank you for this interesting insight. So, well, let's have a look how the European Union and also Germany deals with cybersecurity. And at first, I think the first question to ask is what we are actually talking about. And I would like to draw your attention to an interesting website of the Deutsche Telekom that shows the worldwide cyber attacks on its honeypot infrastructure at the moment. And as you can see, per minute at the moment, we have over 60,009 cyber attacks on its honeypot infrastructure. And well, this is just only one example. 30% of the German companies say that they have been a victim of a cyber attack in the past 2 years. And maybe these figures are not right because, well, very often cyber attacks are not detected. And so we can imagine how important cybersecurity is on that point. And with Corona, the threat has actually increased, as some attacks have been specialized on employees which are working from home. So the cybersecurity authority said that at the moment, they think the threat is also increasing. And as said, the increasing digitalization in business and in private sector makes it necessary to implement also technical and organizational measures to protect us. When you think of smart home or e-health, we have a lot of things that might be protected. When we have a look on what the EU and Germany did, at first, the EU has enacted some regulations for sufficient cybersecurity, especially in the last 5 years. And, well, we have also called directives and regulations. What's the difference? A directive must be transposed into national law of the member state. So the addressees of this directive is or are the member states of the EU. And then we have the regulations. Maybe the most important one is the GDPR, which apply directly. And as you can see, we have lots of different laws, such like e-privacy directive, or the last ones were the Cybersecurity Act and the Cyber Attack Regulation from the EU, but where the most important is the NIS directive, because it regulates that the member states shall cooperate and work together to defend from cyber attacks. And then it was mentioned that service providers that are essential for the supply of a population in a member state must establish protective measures and report cyber attacks. And well, this directive was the first important step. It was a directive that also has a focus on cybersecurity and a direct focus on cybersecurity. For instance, the GDPR has personal data in focus, and also IT systems must be protective that processed personal data, but it's only an indirect focus. When you look at the legal situation in Germany, it seems very similar to which might be in other EU member states, and also what we heard from Israel. So at first, we have the IT security standards, also ISO 27001, or standards from the security governments and security authorities like the BSI, for instance, the BSI IT Grundschutz. So these are the standards. And then we have general law. For instance, corporate law, which said that, for instance, the board of the management of a company must protect the company from harm, and that also includes that they should implement some measures. For instance, data protection management systems or compliance management systems. And this also includes cybersecurity management systems. And then we have that civil law, which also said a product must be secured. So if you have a smart TV, this must also be secured. Above that, we have the GDPR. This has the protection of personal data in focus. But as we can see from the first years, the highest fines for GDPR violations are due to lack of IT security. So, but, well, the GDPR, it said that the IT systems or products by which personal data are processed shall be secured to protect personal data. So we have just that indirect focus, but well, also the civil law, the corporate law, and the GDPR, they affect all companies. Now we come to the sector-specific laws, or the special laws like Telemedia and Telecommunications Act, that are only affected companies which are dealing in that area. So they have also some regulations with respect to cybersecurity, but also some others. And now we come to the IT Security Act and the BSI Act. And this is a cybersecurity law with a direct focus on cybersecurity, and it transferred the ideas of the NIS directive into national law. The IT Security Act was enacted before the NIS directive, but it has also transposed the requirements of the NIS directive. I will come to it later, which companies are affected by that law. And last but not least, we have regulatory requirements or international standards with a focus on regulatory sectors like banks, insurance companies, and so on. And if we look through all that laws, it can be said that the obligation of the company is at first to implement sufficient technical and organizational measures to protect IT systems for different reasons, maybe with a focus to protect personal data or with a focus to protect the company itself. And we also have a number of legal requirements which said that cyber incidents shall be reported to the security authorities or to other authorities, for instance, data protection authorities. So, which companies are affected by the NIS directive or the IT Security Act? So at first, as I said, the NIS directive addresses the EU member states and requires them to identify and to oblige operators of so-called essential services in their countries to implement an adequate level of security. So not every company who is in the sector you can see, such as energy, banking, health sector, is affected by the IT Security Act. It is regulated in very detailed way, that at first you have to check if you're part of that sector. Then you have to check if you have or provide people with an essential service, which is defined in the BCI Act. And then you have to check, okay, what number of people do I provide with my service? And after that all, your company may be affected by that IT Security Act. For instance, a hospital is affected by the IT Security Act if it has 30,000 full inpatients per year. Then we have also, or the NIS directive said also digital service providers are focused to implement technical and organizational measures. And further, the IT Security Act has more sectors in focus. Well, the member states are allowed to have more to regulate cybersecurity for more sectors or to have stricter measures. So in Germany said, okay, also the sectors traffic or information technology and telecommunications, insurance or nutrition are as important as the other sectors, as you can see above. And so they might be also affected if a company has an essential service in these sectors and provides essential service to a large number of people. So what will the companies have to do? As I said, at first, they have to implement sufficient technical and organizational measures. It's not enough just only to implement them. They have also be evaluated very regularly because they must be state-of-the-art. So, because otherwise it's not important to have that high level of security to protect your company against or your customers against that cyber attacks. This is the first part. And then the other one is that you or the company has to report cyber incidents. What is the reason for this? At first, there might be the possibility that the security authority can inform other companies that might be affected by the same attack because they have similar infrastructure or they provide similar services, so that they might be also victim of that cyber attack, and so they can warn each other. Second is that maybe the security authority is able to support the affected company to defend the cyber attack. And the third point is that companies can learn from that cyber attack by each other and can defend the cyber attack by that way. Well, at the moment, if you look to the fines, they're not as high as we know it from the GDPR. Well, it depends on if it's a violation against a sector-specific law or not, but normally a fine can be 50,000 to 100,000 euros, maybe higher. But very often you have to imagine that if you have a cyber attack, very often there's also a violation against the GDPR. And when we have higher fines, as you know it, maybe if you do not implement sufficient technical and organization measures, then there can be a fine up to 10 million or 2% of the global annual turnover of a corporate group achieved in the previous fiscal year. The EU legislator and also the German legislator plan to adapt that current cybersecurity laws, and they have especially in focus especially the German legislator has in focus that the fines shall be higher in the future. And at the moment it is planned that they will be comparable to the fines of the GDPR, so 10 million or 20 million or 2% or 4% of the global annual turnover. We will see because, well, the IT security law is adapted through the last 2 years with a lot of changes. Also more sectors shall be affected. We will see, but we think that it's that the fines will be much higher in 1 year. So cybersecurity is just as important as this is, but especially with the focus on the fines, it's also a risk for the company not to have that measures in place. So that's also from my side, from the European and German perspective. Thanks you for joining our webinar. And maybe last point, I would like to draw your attention also to our Israel group, which also has a focus on Israel and European business. If you have questions to it, feel free to come to us, and yeah, just have a look if you have questions to us. And I see some. Yeah, I see the question focus on GDPR fines, especially in Germany, and that's what we said in the past. And I think also in Israel that was the same, that data protection violations were also brings to or has a cybersecurity violation. And well, the question is, what were the IT security issues that lead to the highest fines in Germany, and how to mitigate them in the future? Well, there were different points. At first, HAM, they watched their employees very intensively. So it's not only cybersecurity point which lead to that high fine because of age in them. And also, yeah, there are different violations to that technical and organizational measures. And if I think in general about all that fine issues, is that the security measures did not have the state-of-the-art focus. So the most important point is that you evaluate your technical measures regularly every year, just to have a look if the state-of-the-art is in place. And that can also be, you can check it by yourself or by IT service suppliers, which might help you also to check if there might be more secure measures that should be in place. I think that was one important point with respect to other companies which are here named in that question. And yeah, I think that this is one point we have to all focus on. Maybe Asaf, do you want to say or add some point on this? Just not with.
So I think with respect to Israel, the whole data protection regime is probably going to change, hopefully going to change in the next year or two. The Ministry of Justice is planning some revisions in the privacy law to make it something similar to GDPR. Under the current law, the fines that can be imposed are very low for data breaches involving personal data. However, there is a threat, as I mentioned, of class actions and the growing trend in that regard. And I believe that under the revisions to the existing law, the Privacy Protection Authority will have the power to impose significant fines, probably not 20 million euros, but significant fines as well.
Yeah, yeah, and I think also when we look at UK, for instance, Marriott or British Airways, and so well, these I think are the highest fines at the moment in the EU with UK, and yeah, it was also the point that the measures were not state of the art. I think this is one important point here, just not only to implement the measures, just to check and evaluate them regularly with the help of third people or not.
Yes, and in terms of state of the art, as I mentioned, under Israeli law, so with respect to data protection at least, the regulations really specifically tell companies what they are expected to do. And every violation of those requirements with respect to access permit management or employee training or supply risk management, it could be viewed as a violation of the regulations. And in addition to that, of course, there are recommendations that are non-binding that are issued by the Cyber Directorate.
Yeah, with due to lack of time, I see we are 5 minutes over. So, well, we will check all the questions here in the chat, and we'll come back to you if you like. And yeah, thank you, Asaf, for that coming webinar. It was a great pleasure to me. And yeah, thank you all, and have a nice day and stay healthy.
Thank you.
Bye.
Bye.